Hello everyone. Good morning, good afternoon, and good evening. Thanks for attending this webinar. Before I begin my talk, please allow me to introduce myself. My name is Wu Wei. I have been working in Shanghai Patent and Trademark Office for more than 20 years. It gave me such a great pleasure to meet you online, and I'm honored to have this opportunity to talk about trademark-related issues about bad faith trademark. After my presentation, there will be about 15 minutes for questions. Also, during the presentation, you are welcome to send your questions through the text message. Now, let's begin the presentation. In the past decades, with the period of trademark examination being shortened and the official fees for filing being lowered, China has seen sustainable growth in trademark application for registration. However, some applicants were found to take advantage of these changes for squatting trademarks of others or holding a bank of trademarks not for the purpose of actual use. Here are some examples reflecting imitation of the trademarks Adidas and Louis Vuitton in various forms, and also a list of more than 800 trademark applications filed by an individual person, covering 33 different classes. These trademarks in bad faith hinders other entities from registering their own mark and jeopardize their legitimate interest. In recent years, Chinese authorities has vigorously advanced trademark protection by cracking down on trademarks in bad faith, so as to effectively maintain the order of trademark registration. The measures involve a substantive examination and procedures, as well as disciplines to trademark agencies and penalties on trademark infringers. In terms of substantive aspect, let's see some example cases showing various kinds of bad faith filings. In the first case, a Chinese individual person filed an application for CHRH designating on bags in Class 18, and it was opposed by a trademark owner of Zara. The postmark CHRH may not be so similar to the side mark Zara at the first sight. However, after an in-depth search, it found that the post party has applied for some other marks that are much more similar to the side mark in design. Apparently, the post party intends to circumvent the examination of the Trademark Office and watch of the trademark owner. According to the decision made by the Trademark Office, it is deemed that a post party has purpose in imitating the side mark. Considering the renown of the side mark, there's more likelihood of confusion in marketed use. Therefore, the post application was rejected on similar goods. This case shows the importance of an in-depth search and the comprehensive analysis of all trademarks filed by the squatter. The second one is a case of bad faith registration of a trademark that is identical with other commercial signs. Zhongze is the trade name of the opponent, who registered and operated Zhongze store on Timor. The respondent filed 55 trademarks in its name. All are same or similar to the name of other Timor stores. And most of these marks were rejected or opposed. The reasons for invalidation petition were mostly focused on the respondent's bad faith in squatting Tmall store name of the opponent. Upon examination, it was found that the trademark in dispute was indeed the name of the Tmall store of the opponent, and that the respondent failed to give a reasonable explanation on the creative idea or use intent of the trademark. Therefore, the Trademark Office determined that the trademark in dispute was acquired by unfair means and shall be invalidated. In the third case, the trademark in dispute is CDJP and is designated on sunglasses and the spectacle cases in Class 9. The site mark is 占地吉普, covering computers in Class 9 and clothing in Class 25. Although CDJP is composed of 4 initial letters of 占地吉普, these 2 marks are quite distinguishable in spelling, pronunciation, and overall visual impression. Also, the goods are not similar according to the practice in China. However, after an in-depth search, it is found that the large number of trademarks registered by the respondent are plagiarized, imitated, or copied from other famous marks, or marks of other famous entities. It is further noted that some other marks of the respondent are placed for sale on online trading platform. That is to say, the trademark registered by the respondent are not for actual use, but for sale. According to the decision made by the Trademark Office, it is considered that the respondent's registration violated the principle of good faith and should be invalidated. The fourth case regards an invalidation petition against the trademark Caravan, registered in the name of a company located in Baoding, Hebei Province. Through business investigation, it was found that the owner of this company also runs other 2 companies, and all of the 3 companies have the same address. It was further found that the respondent, together with the other 2 companies, filed over 200 trademark applications plagiarized from different logos and involving multiple clauses. The Trademark Office made a decision determining that it clearly exceeds normal business needs. The registration of the trademark in dispute was judged as invalid. This case shows the importance of an in-depth investigation of the squatter's background in order to find more clue of bad faith, even from its affiliates. In the year 2019, the Trademark Law of China was revised, focusing on cracking down against trademarks in bad faith by imposing heavier obligation of trademark use. In particular, Article 4 was amended to add that a bad faith application for trademark registration not made for the purpose of use shall be rejected. As you may see from the above cases, revision of the law in fact provides effective means to challenge trademark in bad faith. For better implementation of the law, the State Administration for Marketing Regulation announced an enactment of the rules on regulating trademark filing acts, aiming to regulate trademark filings. The rules provide the type of bad faith filings and facts to be taken into consideration for examination of bad faith applications, so as to evaluate operability and transparency of trademark examination. Rule 8 focuses on facts to be taken into consideration for examining bad faith applications. The first two facts are aimed at determining if the application is not made for the purpose of use. And the facts 3 to 6 are the key to determining bad faith. By identifying the facts of trademark squatting and holding of trademark in bad faith, the authorities is resolute to curb bad faith filings and to effectively regulate the order of trademark registration. The Beijing High Court also announced the guideline for the trial of trademark cases. The guideline specified what constitutes a lack of good faith application without intent to use, as provided in Article 4 of the Trademark Law. The guideline explicitly provides that bad faith will be inferred where a squatter targets different trademarks belonging to a particular trademark owner. This provides a powerful weapon against those sophisticated squatters who copy various trademarks owned by a particular trademark owner instead of different owners. To sum up from the above rules and cases, when applying to Article 4 of Trademark Law, some points are normally checked to find out clue of bad faith of trademark owner, including basic information of trademark owner, such as business status, overall information of the trademark filing, such as number of trademarks filed for and the coverage of classes, detailed information of trademark filings, activity of trademark owner, such as transaction records of trademarks, evidence in opposition or invalidation, and other facts, such as effective ruling on infringement of bad faith application. Another key content of the amendment to the trademark law in 2019 is to stop bad faith application from the source and throughout every procedure of trademark examination and adjudication. Previously, trademarks in bad faith were not regulated during the preliminary examination stage and not initiated by the Trademark Office. Trademark owners have needed to oppose dozens of bad faith applications as they are published, and to undertake massive invalidation petitions against bad faith registrations. These actions are burdensome to the owner, but necessary to keep the Chinese trademark register clear of bad faith filings. With a surge in bad faith applications, there is a consensus among the authorities that the crackdown on trademark in bad faith should be done earlier in the process and be shifted to early stage of the examination. The amended law provides new absolute grounds to rejection, as well as opposition or invalidation. That is to say, the Trademark Office is now entitled to directly reject an application if it is considered or suspected in bad faith. In March of 2020, the Trademark Office turned down 100 bad faith applications in connection with the epidemic, including the Chinese name of Li Wenliang, who was among the earliest to sound the alarm about the virus when it first emerged in Wuhan, and also the Chinese names of Huo Shenshan and Lei Shenshan, which were names of two emergency hospitals built to treat infected patients in Wuhan. In March of this year, CNIPA published a notice on special initiative on cracking down on bad faith trademark squatting. It states that one of the methods to reject bad faith application is adopting a fast rejection mechanism when there are suggestive indications that the application was filed without good faith. Likewise, during opposition and cancellation, if there are suggestive indications of lack of good faith, these cases will be prioritized or quickly examined to reject or invalidate. Here is a video of the Chinese teenage diver Chen Hongchan, who set the women's 10-meter platform final aligned when she scored 3/10 in her 5 dives at the Tokyo Olympic Games. On August 5, when Ms. Chuan received the gold medal in Tokyo, she may not imagine that her name was being applied for trademark registration on the same day in China by a technical company in Shenzhen, Guangdong Province. According to the database of China Trademark Office, there were over 30 applications for the trademark Chen Hongchan filed in just 5 days after she won Olympic gold. Not only Chen Hongchan, but also several other Chinese star athletes saw their names applied as trademarks in various categories, including alcoholic, sportswear, and recreational services, following their success at the Tokyo Olympics. To these applications in bad faith, Chinese authorities took immediate action against the illegal use of the athlete's name as trademarks. On August 19, CNIPA rejected a total of 109 trademark applications involving the name of athletes on the grounds of harm to socialist morals and customs and other adverse effects. On August 25, Zhejiang Yongkang Marketing Supervision Bureau issued a warning against the Zhejiang company for its trademarks applications in bad faith and imposed a fine of 3,000 RMB. In addition, the authorities have also taken some measures to help them to recognize bad faith filings. Previously, trademark applications were randomly assigned to examiners. Thus, filing from one applicant could go to different examiners, even to those working in different cities. But now, more applications filed by the same applicants go to the same examiner, making it easier to track bad faith filings. A new function has also been added to the examination system to alert the examiner to bad faith filings. The function includes objection to the trademark filings and ongoing litigations. Separately, a communication mechanism has also been established among examiners from different regions. Through this mechanism, anyone who finds suspected bad faith filings can inform the examiner. Regarding the penalties against infringement, here is a case of punitive damage. Wise LLC is a global leader in infant milk powder. It originally sued Guangzhou Wise Baby Mental and Infant Products Corporation Limited for trademark infringement and unfair competition in Hangzhou Intermediate Court. According to the judgment of first instance, US Wise was awarded 30.55 million RMB in damages and an injunction. The first picture shows the products of US Wise, And the other picture shows the milk bottle from Guangzhou Wise. On appeal, Guangzhou Wise argued that its use of the Wise logo was reasonable and legal, and there was no subjective bad faith of infringement, and there was no serious circumstance. Therefore, punitive damages applied by the court of first instance is unreasonable. In April of this year, the Zhejiang High Court made a judgment upholding a verdict of 30.55 million RMB, including punitive damages in favor of US Wise. According to the High Court, the defendant's infringement lasted for a long time and made great profits, which met the intentional and the serious circumstance requirement for punitive damages. And the application of punitive damage was not inappropriate. The court determined to reject the appeal and uphold the original judgment. According to the Trademark Law amended in 2019, the amount of compensation for infringement of trademark in bad faith should be up to 5 times the amount of actual losses, compared with 3 times before the amendment. And the upper limit of compensation is raised from 3 million RMB to 5 million RMB if the actual losses are difficult to determine. Also, the law provides penalty against the applicant of bad faith filing and lawsuits. The rules enacted by SAMR further set up a fine that is treble of the legal gains of the bad faith applicant, and no more than 30,000 RMB or a fine of less than 10,000 RMB if there is no illegal gains. On March 3 of this year, China's Supreme Court released an interpretation on the application of punitive damage to the trial of civil cases of infringement of intellectual property rights. The interpretation that defines when a plaintiff may request punitive damage in civil intellectual property infringement cases, how courts should determine if punitive damage should be awarded, and how courts should calculate the amount of punitive damages. Recently, another regulation came into force from September 1 of this year for the administration of the list of illegal and dishonest enterprises. That regulation provides that any enterprise filing application for trademark registration in bad faith will be marked in its credit records in the National Enterprise Credit Information System. Regarding the discipline to trademark agencies, regarding this aspect, according to the interpretation of the amendment to the trademark law in 2019, the penalty against bad faith filings and the lawsuits are imposed not only to the applicants, but also to the agencies. In the case mentioned above of bad faith applications in connection with the epidemic, although the applications were withdrawn by the applicant before being refused by the Trademark Office, the 2 agencies through which the applications were filed were given warnings and fined 70,000 RMB and 20 RMB respectively. Here's another case. A trademark agencies whose headquarters is in Beijing collected enterprise information through online sources line in an email sent to various foreign enterprises that a third party was interested in it to file an application for registering the enterprise name as trademark, and then induce the enterprise to entrust it to register the trademark. The local SAMR in Shanghai determined that such activity falls under the circumstances of soliciting trademark business by means of forced publicity and violates the anti-unfair competition law. Thus, the Shanghai branch office of the Beijing agency was ordered to stop the legal acts and eliminate the impact. And the penalty of 180,000 RMB was imposed. In some other cases, the trademark agencies intentionally misled the applicant to choose their express trademark application services by lying about internal relations with the Trademark Office or ensure 100% success of registration. And these agencies were also punished and fined. Since the year 2019, CNIPA has launched the Operation of Blue Sky, a 2-year-long campaign targeting illegal acts of both patent and trademark service providers, including representing abnormal trademark applications. With over 180 penalty decisions being issued, CNIPA has strived to establish a regulation system to prevent trademark agencies' violations and to foster a business environment with good faith. With the development of legislation and practice, it is said that over a total of 100,000 trademarks in bad faith were banned from registration at the examination and opposition stage last year. Comparing the situation in the year 2018 with that of these 2 years, the number of trademark applications filed by individuals and less known companies is declined. And almost all the top 20 applicants are large companies. From the above legislation updates and the case's judgment, it shows the Chinese authorities' firm standpoint to combat trademark in bad faith. In spite of improvement that has been achieved, it does not mean that there's no longer bad faith applications. A high volume of bad faith applicants may still get some applications throughout the examination process if the goods are different enough from those covered by the mark of the rightful owner. More severely, bad faith applicants are getting much craftier and bad faith filings are getting more difficult to detect. Some applicants are filing for registration for fewer trademarks at a time and do this every once in a while. Some others are setting up many associated companies to jointly apply for trademarks. It remains an uphill battle ahead to fight against trademarks in bad faith. Here are some tips for you to better protect your trademark's rights against bad faith filings. The first is to have your trademarks registered as soon as possible if you have not yet done so. Even if you are only doing OEM or have not yet decided when to start your business in China. The second one is to apply with a wide range of protection, covering not only the goods and services of your immediate need, but also those may be of your potential interest or concern in the future. The third is to pay more attention to evidence collection to prove high renown and strong influence in China, including sales volumes, unit price, profit margins, spread of distribution outlets, marketing share, license fee. Such evidence could be helpful not only in increasing chance of success in oppositions and invalidation actions, but also to claim damage based amount. The fourth is to conduct in-depth search and comprehensive analysis of squatters and associated entities to discover any trace of bad faith, including other marks plagiarized by the applicant to free ride on the goodwill of other parties, and associated links between the bad faith applicant and your partners, suppliers, or distributors. The fifth is to establish a complete watch of your trademarks. With the period of trademark examination getting even shorter than 4 months, it is more probable that a bad faith application could be published before an application is filed claiming priority base. A complete watch will help you to find out such bad faith application and to file opposition before a registration is granted. If the bad faith application is still pending for examination, you may proactively report to the Trademark Office so that there's no need to bring an opposition proceeding if the application is directly refused. The sixth is to try all possible proceedings, including litigations. Maybe you will have a different result. Apart from opposition or invalidation, other possible actions can be tried, such as no-use cancellation. The seventh is that when choosing a trademark agent to work with, it is advisable to conduct due diligence and make sure you have a proper understanding of its credit and the method of charge. As always, you are welcome to consult reliable trademark agencies like SPTL. That's all for what I want to share today. Thank you for your listening. Now it's time for questions. Here I get a question from Alex Gray. The question is there any requirement to the amount of trademark filing to determine bad faith? Yes, it's a good question. I think it would not be difficult to convince the CNIPA to find that an applicant is in bad faith if it applied for hundreds or thousands of trademarks, or if its applications are all copied from numerous famous brands and designated in all 45 classes. However, if the applicant files limited number of marks and designate goods for their core business, maybe the bad faith ground won't be persuasive. as these marks appear on its face to have genuine intention of use. In my view, the relative small number of trademark filings may be offset if there is a great degree of early marks distinctiveness, a great degree of the trademark's fame, or a close distance of two parties' address. I mean, the two parties are very close in the address is very close, or a close association of the two parties' line of business or business operation. Demonstrating these facts would minimize the likelihood of coincidence in creating an identical mark, and implies the possibility that the other party has access to the side mark. In addition, if the other party is a neutral person, it can be presumed that he or she should have less needs for filing multiple trademarks in various goods and services in comparison with corporations that may have multiple brands and carry out various business operations. According to my experience, in some cases, even the total amount of trademarks is less than 10. Trademark filed by an individual person that are all copied or imitated from other famous marks are still rejected for bad faith. That's my reply to your question. Here I get another question from Robert Lee. Is there a blacklist that CNIPA may conduct in rejecting bad faith applications? Thank you for your question. Yes, I have heard about the blacklist complaint procedure available to CNIPA. As far as I know, this is an informal process, and it is not expressly authorized by the trademark law or officially announced by CNIPA. I agree that the blacklist could be a powerful weapon by which rightful owner can effectively flag infringers' trademark filings at lower cost. And also to CNIPA, a blacklist may help the examiner to identify bad faith applications. And the refusal can be issued without conducting substantive examination, so as to result in so that there will be fewer opposition or invalidation petitions, and the infringers will be deterred from pursuing bad faith applications. However, I have two questions. Is it absolute that all trademarks filed by the party in the blacklist are in bad faith? And if a party is flagged in blacklist, when and how will the flag be removed? In my view, trademarks are still examined case by case. If we find a suspected bad faith application, we'd better inform CNIPA of that particular case during the examination of the application. According to my experience, it is likely that the application will be directly rejected if CNIPA determines that the particular application is actually in bad faith. That's my answer to your question. Thank you. It seemed that there's no other question. So much for today's presentation, and thank you for your listening. Thank you. Goodbye.